Hey y'all, welcome back. This is going to be Unit 2B, the Lemon Test. So we'll talk about two cases. The first, of course, is Lemon v. Kurtzman in 1971. The decision was 8-1 reversal of the lower court's decision, and Chief Justice Burger delivers the majority opinion. So the context is Pennsylvania and Rhode Island allow for the reimbursement of, quote, teacher salaries, textbooks, and instructional materials for specified secular subjects, even in religious schools. And the Supreme Court basically rules that this is clearly unconstitutional. And they lay out the three prior tests of the Establishment Clause. The first is that the statute itself, that is written by the legislature, must have a secular legislative purpose. The second is that its principal or primary effect must be one that neither enhances nor inhibits religion. And the third is that the statute must not foster an excessive government entanglement with religion. And they claim that Pennsylvania and Rhode Island ran afoul at least of number three. And basically, in Everson v. Allen, permitted the state to provide church-related schools, the case that we read earlier, with secular, neutral, or non-ideological services, facilities, or materials. Buses, school lunches, public health services, and secular textbooks supplied in common to all students are not thought to offend the Establishment Clause. So you can give religious schools broad-based public health benefits, right? Health and school lunches and buses and textbooks that all the students in the state have to use. So why is there entanglement here? And they say there's really two reasons, right? First, that teachers in private religious schools can't really be trusted to teach only in a neutral, secular manner, right? And second, that Rhode Island has a mechanism in their law in particular for reviewing how much teachers spend on religious secular materials. And they say, quote, that kind of state inspection and evaluation of the religious content of a religious organization is fraught with the sort of entanglement that the Constitution forbids. It is a relationship pregnant with dangers of excessive government direction of church schools and hence of churches. So they strike down these laws. The second one is Zellman v. Simmons Harris in 2002. You got to remember the court has been moving toward a more sort of conservative position over the 80s and 90s. And so the court in 2002 votes 5-4 to affirm the lower court decision, and Chief Justice Rehnquist delivers the majority opinion. So the context here is that Cleveland, Ohio school district is just failing so completely badly that the state has taken over the school districts. And Ohio passes a law called the Pilot Project Scholarship Program. So if you live in a failed district, the legislation applies to you. The state provides tuition to attend public or private schools of the parent and student's choice. The state provides tutoring to students who decide to remain in their district. And what we find is that 96% of those who used this program and transferred chose a religious school. And the district and appeals courts basically said that this law violates the Establishment Clause. But the Supreme Court disagrees, and they say there's two main reasons. The first is that the main goal of the law is not the establishment of religion or anything, it is to provide better education to poor people. And then second, it's because the parents and the students are the ones who are actually determining where to use their tuition money. The state is not providing any sort of direct aid to religious organizations or schools. And so they overturn it and say that the Ohio law is constitutional. Justice Souter dissents in a really strong dissent with 4 of the 9, and basically say that the Establishment Clause is being broken by Ohio, given the vast amounts of money that are being funneled into religious schools, and that tax dollars are being used to support religious instruction. And then, so it should fall under the Everson rules, and yet the Supreme Court, who has taken this right-wing turn, is changing the rules according to Justice Souter. All right, so that was a short one. I'll see you for the next one soon. Have a great day.